Fiaduma wani na one acting information minister caretaker Kojo Oppong Nkrumah twaso wo mu wi a Kofi be sign off wo mu na wo Supreme Court na che say dey wi Kofi twaso.
All right, Captain Masomo Ewaha na so dey kind no acting information minister Ewaha ye no ebedi enko me nim say by all means be gina to di kan tete yakra na say okọ presidency afi hu ya na wasan atra na adwuma so na kwese na adwuma no ne so ani but ma menye na dwen ewo de ekoso yi ho ona bo Kojo Oppong Nkrumah makwa ba
Kofi ezan
nyame adom ye ho ye pa ye hwe de ekoso enne looks like only NDC fala ya for nanim any lawyer chachu animu a mo take your mobile surprise nipa na nko mo hwesem ko benya kwanya bisa o mo nsem bi no se say enya nkonko ba na sa nti ama nyema bia na nko mo hwe no wo mo nsa entumi enka wo mo hwe aho ada na na ka mo strategy ho na
me ni madukuru nti a o mo hwe aho san se bi se wo de wasema ba court a wo na wo se wo kan wasem che court no wo kan ye evidence act section 14 section 17 o say wo de wasema ba court no wona utumiri echeresie he who alleges must prove uchira wasemu wia na fi court ahye say okay wo asem no ye de obegina court no se ya kan asem ama na dum pempensuo bia se wanyiwa no a asem no ba bia ekono ebutia wo udi bem nti o se oyiwa no nti criminal case a enka first prosecution na be any case or any case we are free no catch record a formal announcement to court and say my lord I arrest my case and I say I close my case and that is the case of the prosecution say defense no hwe na said their prosecution aka na hurada sem papa bi anymore defense no to me raise the friend submission of no case say my lord they are keke they ansem no atoto emra na ode ma begina ha na fact account no improve case bi a hu hia say me defend me hopo court no to me hwe kasampa one coincidence asem bia masa obi anko fie ana say court no to me kasa da bi asem na du no wa kama na bu atia wo ase wanyi wa no a ye bebu for into bon say obeka cho say bie o defense we hwe evidence act no mo in fact we say we hwe CI 47 ni CI 87 no crampo am ran kire say sempo mpo ukase ube defend ho a enye by force say wo be kwa ko gina witness box no ma ko defend ho utumi ka che court ne say my lord ensem o maka nyina say we ni o mo evidence na ene so mo na fa no sa na fa bu asem no mini asem bia ka say we ene o mo evidence ni nyina de a into call under order 36 a o say we ni o ma asem nyina wo re fa me nka ho hwe fa bu asem no na wa be hu say we ye de kopo a ye nyinam enti so what application first respondent lawyer and second respondent lawyer o ma say we any omo evidence we any omo witnesses no we any asem omo wa man kofo tisi kromo ebi mu pra ebi mu wuye omo ka che we ni ono bi wia ye yonkofo hita ne we any asem no ni na ani ene ehun hia say isi say obeyi na no korampo because isi hwa omo make asem bia before the court second respondent for lawyer for so here omo make asem bia before the court nti na yama court na so ati say we de nya de a ye be ha ye ho kram say ye court nim for masem na mfemu asem no na no na owura chachuchi kata say debi o say dey isi penny be gina box no no to
o hwa ho na adwen no wo say omo nya ne ba bia misa no monsem court dem ha no benya na tme bisa o monsem na obia adwen mu ada ho fan say for instance about na say no declare figures we ade o sande for ba ye nipa be no ne mu tu ho agina but now no it looks like he's been denied that opportunity.
No, that opportunity has not arisen. And yes, he's been denied. You're correct, no. And you're right. Say, because Kofi Aduma ni masama no court. Inti yemfani beji na daka mu mami ntoto na. Na say nka sa na be na me o chano pass governor. O ye bibi o Bank of Ghana na me mpa na nka mesoma be samano. Ne na beji nam na mesoma start toto na no. Minister of Information ye bibi no bi mpa no ahara be samano. Ne na beji nam say ye toto na ye nye ne sa. Wo prove case the entie wo say ebia ye bu assemblity ano ono a o tie case na no hwe no say akọ evidence o de gu court anim say man ko gina ma yima no a ye bebu atia me a ono no be so ya ko bi anhye no na aba no ambeka hwe na be uba bisa say nti okay wo de ba court sia betre o figures a wo de ba court wo say we nya correct wo de correct one na advise my lord man femma say wa we o coalition we ye den na onya say my lord no man femba mo fa no begina ma me bisa na sem court in yes or set precedent be. Two bones a lawyer for no advance argument. Now I mean differentiate between when 2013. 2013, yeah, buy no. Yeah, the pink sheets from about 11,000 polling stations in the buy. Bear 4 million votes was said and I was say make any year. No, in fact, I'm saying bear 1 million votes or so. And I actually say, some votes win was striking out. I baby another win because votes win illegal votes. Yet the evidence by petition and Nankasa 4 boxes. Mamadou Baumia Nankasa no a petition. 2013 or 3 petitioners. Nana Danko Kufado, Dr. Baumia, Jacob Belamter, when the baby call. Dr. Baumia a quarter box him. No, ye any case. On obey you and I were not there. Trichrimu. We no. Obia and easy. What is a court in the share easy? A Farijana no cast as a man cotton box him one. Confoy baby, I'm the assembly do no. A year buetiame. To buy and on no subject more court in tea and assembly and say, judges need be so many yarding, be said there be omni and yarding. And a crowd who's a pie. We petitioner no, or buy an on fapping sheet in on far regional coalition, Utu assembly tea and all the abacity and I was the 9 or the acousity. And then Rojo, court now my crime, I am going to the source of the witness statement. And can a lawyer 4% prove say, ne yari no say, or yari tune to me, mano, you won't send me bisa, as I don't go that do be a bemba court and my crime, my uncle, and say, until we are when you know enough, you will say by force, Yemfa Peter McMahon who made them, Yemfa about penny. Jimens and Benjamin, and Ramon who can some subject Teresa own cancer beer. Until when I say about court be determined your coin.
They say that that's our 7 year, I don't know.
Oh, there be, I don't know. There be Sanka, I was Sanka by Nanka petition and approving the case. We would hear coffee. Utra court tea and semina. I thought assume a petition and approving the case. I thought assume a petition and let me approve will be in 50%. Fred, I'm catching our supporters. 40C Chrome, a be prior, a be wooye. Then the road Georgiana Supreme Court and him, the Bible sharing and sa. What you to say, I'm for better 3 hours, not tea, about penny in the office, and tea. The Omokan Bonting, need your moya or damn hono. And only. NDC supporters, our questions, a be so penny for pass, and I said the Amokatra and Yanuni. As someone Mokatra and say, you winnie. Baby Crumbs are winning 141 seats, and I'm going to tell you about 140. Now, if you're working majority, just 138. Once you're winning, I don't know how high. I feel mobile here. One can some more diatum. One, the calculator shows if you bought or you say 4751. For 30 man count, 4751. You 30 man 4751. Until there was will be 50%. No, go for your way.
I know Kojo Oppong Nkrumah, but tea no, man for biscuit now, biscuit now.
Until me na me feel saying Kasemo Bekane say there be sa semono sebe etutu na ni onyamase na enye no kre say oja adwuma no ho be 3 hours not in my many office enum tea no adwuma de no kɔ hɔ na no kɔyeye anu yo edema say tea de man na biscuit de ya man afi kra me na ma ferry but ni na share judges ne nsa omo na be determine assembly in the end.
That's it. Honorable Kojo Oppong Nkrumah.
Okay, it's okay. Let's come back.
Distancing.
This is Angel 102.9.
Okay. Thank you very much and good afternoon.
This is Angel 102.9.
Today, two things happened in court.
Is Ghana's
First was the cross-examination of Kojo Oppong Nkrumah. So let me talk about that first. Mr. Kojo Oppong Nkrumah was cross-examined by both counsel, and certain things stood out. One, the issue of duplicate or double sheets or multiple sheets for particular regions. So, for example, Eastern region had 2 sheets with different numbers on it and yet the same valid votes. And in court, we saw that apparently there was a third one lurking somewhere with a different timeline. We also saw that, for example, if you read his witness statement, Greater Accra was also an issue. Greater Accra, the numbers on the sheet did not add up. And interestingly, if you read the witness statement, you see that what was published, or the summary that was published on the website or by the EC, was different from what was actually given to the agents in the collation room. The other thing that came up was the fact that this was the National Collation Center where the returning officer, Jean Mensah, was supposed to be in control. We heard from their cross-examination that for a period of 3 hours, the agent of the petitioner was trying to get his problems or the issues that he had seen across to her without any success. We also saw the fact that they state that if you have signed the sheets, even if there are glaring problems on the sheets, nobody is going to do anything about it. This should give us all cause for concern. But even more importantly is the fact that Rojo Metununu reiterated under cross-examination that it was the EC chair who asked him to convey message, information, whatever you describe it, to the petitioner. And if you read the witness statement, you realize that it was about a potential stakeholder meeting to discuss the concerns they had raised. And of course, as soon as they left, the EC and its chair, Jean Mensah, made arrangements to declare the results. Now, all these are issues of concern. Now, you probably would ask, how does this relate to the reliefs? If you have several collation seats for one region, which one was used for the declaration? I don't know. If you have sheets with different words in numbers in words and numbers in figures, which are different, which one was used for the declaration, or for collating, or for adding up the numbers? The only person who can tell us this is the EC chair, who's the returning officer. And that leads me to the second issue that rose today. They claim that they are not going to, or they stated, it's not even a claim, they stated clearly that they are not going to call any witnesses, even though they have submitted witness statements. Now, I don't know whether it's evading, running away, whatever, but they are avoiding or running away or evading the cross-examination of Mr. Chikata. We should remember that this is the EC, which has a constitutional duty to the people. They have an obligation to account to us for our stewardship. And they say they are not going to take the witness stand. Well, tomorrow we'll see how our lordships will rule on this. And the issue was raised whether it's a human rights issue. I don't know. This is the EC chair, a body created by the Constitution, which has an obligation to account to us. They are obliged, they have a duty to respond to our questions. They cannot, EC cannot hide under human rights to say they are not going to respond to us. So I respectfully disagree with her ladyship when she said it is a human rights issue. It is not a human rights issue. They are obliged to respond to us.
This is Angel 102.9.
I can hear you. Yeah.
This is Angel 102.9. This is Ghana's own Angel 102.9. 102.9.
Won't I say that? I couldn't hear the rest. Yes, I think we still do. Because there is the issue of the declaration, which is why we are in court, where we stated clearly that even on the face of their own documents, nobody got 50 plus of the votes, of the valid votes. And in addition to that, as at now, the EC itself has come up with different figures. They're ever-changing figures. Which one is the valid votes, which is supposed to be used for the declaration? They haven't answered that question.
Council, you are part of the petition making the point that no one got more than 50% of the votes. That each time your witness have been cross-examined, you told us that you were satisfied.
This is Ghana's own Angel 102.9.
Witnesses have been cross-examined. You've told us that you were satisfied with what has transpired. Should it not be in your interest that you've closed your case and the respondents you are seeking reliefs against are saying that, look, we don't intend to lead any evidence to show the contrary, that people had more than 50% of the votes cast? I mean, should that not be good news for you, actually?
And that is why we are going to oppose the application tomorrow.
Closely linked to that, or following up on that, is a question of the relevance of that particular cross-examination to your case. The lead counsel for the Electoral Commission had made in his submission that indeed they are satisfied with what you have brought to court, and they think that the court can go ahead and make a determination without the benefit of the testimony and cross-examination of the returning officer. How crucial is this cross-examination to your case?
First of all, if to the court, we did not have a case. The parties have submitted witness statements. But my major concern is with the EC. That is accountable to all of us. The EC cannot say. Major concern is with the EC. That is accountable to all of us. The EC cannot say that it will not respond to questions raised by a petitioner, by a candidate.
One question that ran through the cross-examination is, with all the three witnesses you presented, is do you have figures that shows that the second respondent did not get the figures, the percentage that he had? That was one of the questions that ran through. I want to find out, you realize that, no figures have been provided by the witnesses and then the petitioner. Do you think with this, the court will grant your reliefs? Because the question that went through was, do you have figures that show that the second respondent did not get the percentage that he had?
First of all, have been churned out. Please go back to by the EC. I keep answering this question. I've already answered it. That by the declaration, by the different figures that have been churned out by the EC after the declaration, it is obvious and it is clear that no candidate got 50% or more of the votes. As to whether, what was the question? With regard to our figures, that's irrelevant to the case. We've come with the EC's declaration itself. Yeah, irrelevant to the case. We've come with the EC's declaration itself.
I have a question. How compulsory must Jane Mensah's cross-examination be for your case to succeed? In other words, is the success or otherwise of your case hinged solely on her cross-examination? And if that fails based on what the bench will rule tomorrow, would you then determine that you have a lost case because you are unable to cross-examine them?
Of what you're saying.
If the bench rules tomorrow that she should not be cross-examined, would that throw your case out of the window automatically?
Well, first of all, we'll take it from there. We are going to argue whether or not the EC and the second respondent should take the witness box. Our view is that they have an answer there. They have submitted witness statements, and they ought to be cross-examined on those matters stated there, because that is what they are using to challenge our case.
Yeah, but so my question is,
yes,
your argument has been put forth in the courtroom. Now, the determination will be made by the bench tomorrow. Is the success or otherwise of your case hinged solely on this cross-examination? That's the question.
You note that when you go to court, your case is not just based on your pleadings and your evidence. There is also an answer, and in this case, there's also a witness statement. And we think that it is important for us as petitioners to be able to cross-examine the EC in particular on the matters that she said.
Pass yedi a petition at the bar court 30th December. Yan wie kra na ode answer emuaye at the bar petition also. Samuaye no ayensem na ode to answer no so. Afi yesi fa wenum asem evidence a support wo answer no fa beto court n'anim a wo se ndie mempe meko. Na se wo mpe na wo kɔ dia ende de aba court no se court no enye den emfa mayen na court no nka se order for runoff. It's as simple as that. We enya de aye ni electoral commission ye ba be twentwen ho asem ye ne de asem aba court se two candidates no obia bia ni ho a onya 50%. Wo the answer the aba court se enye no kre yes be yi anu edenti asema Jomahama aka no enye no kra o se ne de mempese menka se woni bibia edi hinta denti na wudwane sebe akankasem yes udwane ekọ ahimfie kanea ene nkire so ayeden agise ye tutu wenum ayeden asem emne du si ebe tutu wenum asem a o se dabi we de misro dabi we de yesre adabraka ye mame embra witness boss no ejuma o di no Ghana bia 30 million Ghanaians onu kwa na etimi di se ejuma die no onu kwa na returning officer onu kwa na constitution edi se ejuma die na di ayeden edi ahye ne nsa me amika se mintimi di se ejuma die no John Dramani Mahama enya di obetimi ayeden edi se ejuma die nipa ba akopɛ sada no one na wo ye declaration one na wujina ho simpie so se a ina okasaye be kire ye akonta a wo ye ya wo arrive at that calculation a wo se ne de memma we de yesre no yenko akonodi yenko no gopo ye be ye no court da mu ha yesre no se ye na ye no osomo ya sa da ye no etwam on your mra na nyame ya adoma ekina ye beba near the legal argument at the abetting at the abetuja. Sebe. Uni she a hinta. The car when you must say, Afarijan, the first now unim the one. Amra nanado danko kufado at the petition at the bar. Unim the anan walker. The okay in say, presiding officer and sign it, polling agent are signing by yambo about to know any day engu nien declare or no man penny. Afarijan wa maha yen tutu na num asem wan hu Philip Addison anu the pink sheet e de kire no na ye ma me die den kura no ehu nti a sebe den kura no odi sie Ghana fo ono na etua no ho Sebio, ono na etua no ho. Na owia onko parliament enko jisika. Enye Ghana ye foto ne de ma no. Nti sebe ekwan be nso no ogina ne a ose no de. I mean, look, edwe bi ya ba ejuma a oye num. Ye nyina esi ehu se dwe ahamaso ewo ne mre. Eye court da mu ne ewo. Ye nhwe akira de besi. As for the Rojo Metununu ebeye ne de sebe ye nyina ye den ye hwe ye. Omo ye ya so mema wa ye den wa contradict no ni nyina ye den anye ye. Baby a ogina no hwa no ye den ogina. In fact, ebeba mu kra se emra mo lawyer ka se NDC ni bia mehunu na omo an eva mu si ye no ene ye hu se okra omo maniti one with the Yankupo and no osro say oba witness boss no mu a sanyo ma nyina ba be de diana sebe ye nyina ye hu se eye Ghana ene ye som enye obi bia medam ase
This is Angel 102.9. This is Ghana's own Angel 102.9. 102.9. This is Angel 102.9. This is Angel 102.9. This is Ghana's own Angel.
So, colleagues, let me know if you are ready, and then we can proceed. You're good? Good afternoon to you all, and thank you for joining us. Today hasn't been as long as I think the last time we were in court. Today, two major things happened in the wells of the Supreme Court. First is the formal announcement by counsel for the petitioner that, my lords, we have closed our case. And you notice that the court, by court, admitted that they have formally closed their case. I'll speak about what that means and what it means for the next step. Prior to that, you saw the petitioner put in the box his third witness, who I believe many people were hoping will help adduce evidence that will advance the petitioner's cause. It is not for nothing that anytime we come before you, we go over the issues that the court is seeking to determine. Because sometimes you may hear they are in court, they are in court, but the issues may get missing. So please permit me, when I repeat the issues, what the court is seeking to answer. The court on the 20th of January 2021, after listening to the petition and the answers and reading the memoranda of issues, set down the following issues for the determination of the petition. All of the conversation you hear going back and forth is about these issues. And the petitioner is being required to bring witnesses to adduce evidence to settle these issues. Issue number two, because the first is an issue of law that the court will determine. Issue number two, you're expecting that when witnesses mount the box, they will provide evidence to the effect that based on the data contained in the declaration by the first respondent of the second respondent as president-elect, nobody got 50%. You are expecting that when a witness mounts the box, the witness will provide evidence to the effect that the second respondent, if you include or exclude Techiman South, did not cross the constitutionally mandated threshold of 50% plus one. You would expect that when a witness mounts the box, that witness is adducing evidence essentially that will prove that the declaration of the first respondent on the 9th of December was in violation of Article 63.3. Or at least you expect that what the petitioner has listed as errors in the petition, this witness will provide evidence that shows that these errors and these alleged vote padding affect the outcome of the presidential election 2020. So far, we have seen the petitioner put 3 witnesses in the box, and we are of the view that the court will do a good job in determining whether or not these witnesses have provided any evidence that supports the petition and these issues that the court is seeking to determine. Now, it is upon the completion of this, and note that the petitioner advertised 5 witnesses and ended up calling 3. It is upon the completion of that the petitioner has now announced to the court that this is all that the case is about. And you heard Mr. Chikata say, "My lords, our case is closed." And His Lordship, the Chief Justice, say, "By court, the petitioner's case is closed." If we were in a criminal trial, what will happen now is that the court will have to determine whether or not a substantive case has been made, in which case the defendant or the defense may now raise an argument that maybe no case has even been made. So I don't even need to bother raising a defense in the first place. In a civil process, there are similar remedies. What you noticed happened, which is the second matter I'll speak about, is counsel for the first petitioner announced to the court that the evidence, counsel for the first respondent, I beg your pardon, announced to the court that the evidence that the petitioner has provided is enough. And the cross-examination that has taken place is enough. And that the first respondent does not intend to call witnesses to adduce evidence, any further evidence before the court. And counsel on the side of the second respondent has advertised same. Because by now, whatever evidence that the petitioner has put before the court, once the case is closed, it is believed that they have brought all their evidence and they have made such a strong case. And so it should actually be to the disadvantage of the respondents if they say that they don't even intend to call witnesses to adduce evidence. But you notice that the petitioners are not too happy about it. They want literally to compel the respondents to bring in witnesses to, I don't know, adduce some evidence that may help the petitioner in his cause. The court has adjourned, as you heard, to tomorrow morning, and we'll listen to the legal arguments on both sides. We are very, very happy, extremely happy that the petitioner has come to the end of his case and has adduced all the evidence that he has. Evidence which is supposed to prove that nobody got 50%, that whether or not you add Techim and South, the winner will change. That Article 63.3 has been breached. This is all the evidence that they have, which they have made available. And we'll hear what the court says tomorrow as it proceeds to deal with the matter. Yes, sir.
102.9.
And we'll hear what the court says tomorrow as it proceeds to deal with the matter. Yes, sir.
Okay, I think. Thank you very much. You have said 10 times that you intend bringing at least Mr. McMillan to testify. I know you're not responsible for the first petitioner's witness. They have said categorically that they will not present her to testify. But why has the narrative changed? At least we know that Mr. McMillan was going to be in the witness box. Thank you very much.
I want you to go back and play the tapes of our press briefings here. The narrative has not changed. We have always insisted that the onus of proof lies on the petitioner. Sections 14, 17 of the Evidence Act are very clear. He who alleges must prove. You have told your supporters across the country that you won and that they should get on the streets. People died. People got injured. People got involved in infractions with the police and got arrested because you told them you won. When you came to court, you abandoned that and said, nobody won. And the court has invited you to prove. We have always maintained that we are waiting for their witnesses who will adduce evidence to prove that at least their second argument that nobody won is true. And we have always maintained that Chairman McMahon is ready on standby, that when they prove this and it becomes necessary for us to go into the box and prove that what they are saying is not true, because they would have made a preliminary case, we'll do so. You have seen their 3 witnesses. The court has seen them. The whole country has been watching. We've all been waiting with bated breath to see the evidence that nobody won, to see the evidence that when you add or you don't add Techim and South, the results will change substantially to mean who crossed the 50% threshold, to see the evidence that Article 63.3. And on our side, we are not convinced that any such evidence has been put there. That is why we have announced to the court that we don't intend to call any fresh witnesses or any witnesses, because on our side, the view and the belief is that that case has not been made. So the narrative has not changed. The whole country has been waiting. All the NDC supporters, I'm sure, have been glued to their TV, waiting to see their officials prove that nobody got 50%, or that at least the first argument holds true. Now they have announced to the court that they have finished their case, and I'm sure many people are surprised. Now the second part of your question about why Chairman McMahon will not be taking the witness box. A party advertises to the court how many witnesses it chooses to call, or its intention that it may call X or Y or Z. And as you heard the bench in exchanges with the lawyers, there are questions about when that election takes place, which I think questions will be addressed yesterday. But isn't it interesting that Mr. Mahama himself, the petitioner, did not mount the witness box? And we are not arguing about why he's not in the witness box. Why has he not taken the stand? Why has he not taken the witness box? Can anybody force him to take the witness box? The petitioner himself. Even to court, he has been here twice, and other representatives come on his behalf. Can anybody force Mr. Mahama to take the witness box? Can anybody force the other two witnesses of the NDC that by force they should get into the box? So if you're asking about Chairman McMenu's or the announcement that we will not be putting anybody in the box, as I've mentioned, it is because our lawyers are of the view that that basic threshold has not been met. They have not adduced any. I don't know if you have seen evidence that shows that nobody won the election. Or that 63. This is what they told the country. This is what they told the court subsequently when they came. And our lawyers are of the view that that hasn't happened. That is why nobody will be bothering to take the stand. And tomorrow they will advance legal arguments to that effect. But if your question is about why he isn't taking the stand, maybe we should ask why Mr. Mahama is not taking the witness box as well, and why they are not bringing the other two. Yes, sir.
Counsel, if it happens that tomorrow, we don't know, the justices agree on the other side that the witness, the EC chairperson should stand in the box, are you going to call Mr. McMahon eventually? The
calling of Mr. McMahon is very different from the EC's posture. Mr. McMahon is representative or is a witness for the second respondent. We are of the view that the petitioner has not crossed that threshold, and that's why we have announced to the court that we will not be calling Mr. McMahon to bother to even give any evidence because no substantial case has been made. That is the opinion of our lawyers. Now, should the EC change its mind, or should the bench decide that the EC should go in and answer? It has nothing to do with our side. We have made a case. The court will make a determination on whether or not we should be forced to put a witness in the box when we are of the view, and the evidence, I think, as has been seen by many, is in question about whether or not they have made a case as they had advertised earlier. Yes, sir.
All right, sir. I believe that this is in the interest of all Ghanaians, and irrespective of the fact that this is between the petitioner and the Electoral Commission and Nana Akufo-Addo, Ghanaians are also expecting an answer from us. And so I'm asking that why don't the second and first respondent allow EC to step into the box so that he will clarify some notions made in some heads of some people?
Yeah, I think that's a very good question. Last time you raised a similar question, I made the point that this is a court of law, not the court of public opinion. This is, with the greatest of respect, this is not the Public Accounts Committee of Parliament that the EC must give us some answers. This is not budget hearing of Parliament that the EC must come and justify its budget. You have come to court with a specific petition, and the onus of proof is on you to show to the court that this is the basic case, and therefore somebody has a question to answer. Where you have not met that threshold, you cannot resort to what I keep telling you are propaganda answers. That when you lose the legal battle, then you resort to propaganda questions and answers. That, you know, it's in the interest of all Ghanaians, and so why the EC? No. And let me also make a distinction. In the 2013 election petition, the Electoral Commission mounted the witness box. Why? Because the petitioner came to court with results of about 11,000 polling stations. Pink sheet to back saying, and to make an argument that when you deal with the lack of signatures, the multiple serial numbers, etc., which are all infractions, and you strike them out, you have to call a proper declaration of the result that Nana Addo Dankwa Akufo-Addo is the winner of this election. He came with evidence and made a case. You have been here and you have heard the bench labor asking the petitioner over and over again, where are the numbers? Where are the numbers? Where are the numbers? And time again, they make the point that it's not even relevant to their petition and that they are not here looking for new numbers or anything or a new declaration, but they are here to question the conduct of the EC chair. The two cases are very different. One came to court with pink sheets and evidence, and the petitioner in 2013 mounted the witness box. Dr. Alhaji Mahmoud Baumia, who was one of the petitioners, mounted the witness box to advance his case, made the case, and therefore the EC had to get in the box to respond. You have been here. Have you seen their pink sheets? Have you seen their regional? Have you heard them answer the questions when the bench puts the question that what are the numbers? So the two cases are different, and it's not, that is in the public interest or is in the public interest. This is a court of law, not a court of public opinion. Yes, sir.
It is true that the petitioner has not been able to give out any figure that show that the respondent did not win the election. But the argument they are making is the consistent change of figures by this first respondent is the reason why they are in court. And you think they have no case?
The court has said that as the last issue. The last issue to determine whether or not these so-called errors materially change the result of the election. It's one of the issues that the court is going to determine. And that is why at every material moment you hear, for example, the Venerable Akoto Ampao. And today you heard him ask that same question of Rojo. That I want to suggest to you that this your 1,700 or so that you are talking about is not material enough to affect the outcome of the result. You heard that question, and you heard his answer. He was being evasive, but you heard his answer. The point is that the so-called errors, or the phrase that they like to put out, the propaganda phrase they put out, the ever-changing results, like how they put it. Even if you admit that those are substantial errors, the question is, does it change who won the election? If somebody beats you by 500,000 votes, and you come and you say, I saw 1,700, which I describe as vote padding, the court wants to determine whether or not it is substantial enough to change the result. And that is why at every point in time, we keep asking them to provide the court with those numbers that will show substantially that it can change. And you hear them over and over again decline so to do. I think that for the millions of NDC supporters who are watching across the country, they will also be asking questions. Because now there's a clear difference between what the petitioner and his colleagues told them on the night of the election and what they are saying in court, and some of the admissions they are making in court. For example, you heard Mr. Rojo Metununu admit that for almost 3 hours, he had left the strong room and was at the reception of the commissioner and admitted that he was having tea, but then, argued that there were no biscuits involved. These things may sound as funny, but the supporters of the NDC down there across the country will be asking themselves that, so while they were out there, having been misled that they had won the election, this is what their seniors were doing at the premises of the Electoral Commission. This is what they told the public. And now when you come here, you have to make some admissions. So the jury the bench will make a determination at the end of the day. Colleagues, are there any other questions? Let me yield the podium to my colleagues to translate it.
Abusianfo ye bedamo ase ene eye da toso eye dumienu a ye de aba eye Supreme Court hay na ene ye nya ye nim na no fiada ena NDC eto nsa anase petitioner Openi Mahama eto nsa edifre na dance ni a otoso miensa ene ne twato na ene ye toto na no na toto na no ye nya ye hu ensem ni bi epie na ne hu hia ye pa no ɛyɛ nsɛm a court no ɔde asi n'ani so sɛ ɔbɛpa ho muayɛ ne hu hia nyinaa ne sɛ Nana do Dankwa Akufo-Addo, His Excellency onya ɛyɛ ɔhanom nkyekyɛmu aduonum ɛne akyire anaa ɛno yɛ ade asi court n'ani so pa ye eti nsɛm a wobɛka biara no ɔwɔ sɛ wonya so mmuayɛ na wonya ne nyinasoɔ ɛnɛ ɔmofrɛ Rojo Metonunu yɛnyina yɛte nsɛm ne bi ɔkaeɛ ɛnɛ yɛbusa no ɔse ɔno no adwuma ɔbɛdiiɛ no ebi wɔ hɔnom a ɛyɛ mfomsoɔ ɔde ne nsa ahyɛ krataa ase wokɔbusa no a ɔse ɛyɛ mfomsoɔ ɛna ɔyɛɛyɛ ebi wɔ hɔ nso a ɔse ɔyɛɛyɛ sansa na ɔmpɛ sɛ ɔbɛyɛ akwansideɛ ɛde ama Electoral Commission wei nyinaa no ɛyɛ nsɛm a wotumi sɛ na ɛnsisi soɔ afei koraa de ɔse isi ɛpamo no ɛfiri dan mu hɔnom ɛno yɛ ɛnɛ ade baako ɛbɛtɔ dwa ɛnɛ yɛhu sɛ ɛno nso no ɛnsisi so ebiem ade baako ɔsa kan yɛ kora mpa ɔadmiteɛ Electoral Commission ɛma accreditation obia ɛnan o eti sɛ bibi kora mpo si na mpanifoɔ mmienu sɛ mokɔ baabi a ɛyɛ mmienu na aka akyire no awɔ sɛ nkɔmutumi gyina mu wei yɛnhu ne saa wobusa no nso a onya ano yie mfa ma wo ne ebusa ne sɛ dɔnhwere ɛyɛ mmiɛnsa a wokɔdii wɔyɛ ɔbaa pani Jane Mensa office a na ɔte hɔ nom o nipa a yɛde wakɔ sɛ kɔna kɔdi dwumadie kɛseɛ sei sɛ wohwɛ ɔno ara ne krataa ɔde abrɛ court na wohwɛ ɛpɔ a ɛtɔ so mmiɛnsa nea ɔkyerɛ nyinaa ne sɛ yɛde ne kɔ hɔ sɛ ɔnkɔ na ɔnkɔhwɛ ma a ɛreba no na n'ani gye ho a na ɔde ne nsa ahyɛ aseɛ ɛwɔ no akrataa mu enipa a yɛde wakɔ akɔtena esi akakye sɛ kɔ na kɔdi dwuma kɛseɛ sei ɛfama wo party wokɔ yɛ a wagya dwumadie no asi hɔ ɛna wote esi ɔbaapa office dɔnhwere mmiɛnsa ɛna wonum tii na yɛsɛ busa wa wo sɛ emom na biscuit nka ho wei ɛyɛ nsɛm a ɔpani Rojo Metonunu ɛkɔka yɛ o na anu bɛka yɛ a ɔpani baako ɔbaa Dr. Kwesa White ɔso ɔno nso agya ne charger wɔ fie nti ne phone bedum yɛ wohwɛ nneɛma a ɔmo ka ne nyinaa na yɛ sɛ ɛnyɛ adwuma pa bi ɛna ɔmo baa yɛ a ɔmo ba ebedi ɛwɔ hɔnom nti ɛnɛ yɛhu ne nsɛm no ano totoɔ no sɛnea esi kɔɔyɛ na ɛberɛ a yɛwie ne nyinaa no yɛtoto n'ano nyinaa wieyɛ isi ewie ne deɛ ɔpani akotampa wie ne deɛ ɛna isi ɛde tu dwa sɛ wohwɛ mmara nim na wohwɛ ɛyɛ ɔda 36 ɛyɛ 47 no 36 rule 4 na wokenkan hɔ ba no a sɛnea ɔmatie ɛyɛ ɔpani asie do nketea ɔmatie n'ano asɛm na ɔmatie ɛyɛ Dr. Kwesa White ano asɛm na ɔmasɛ tie ɛyɛ ɔpani Robert Joseph Metonunu ɔmatie n'ano asɛm ne no dabi ɛho hia koraa sɛ ɔmasɛm no kɔ mbɛdi adanse bia biom sansa nsɛm no nyinaa ne nyinasoɔ no ɔmantumi amfa nyinasoɔ biara no amma ɛna ɔpani kyatwu sɛ dabi sɛnea tie biara na ɔsɛ yɛfrɛ no na yɛde ne ba ɛhɔ ɛna court ɛde aba bɛduru na wotie nsɛm no bi a yɛnnua no mandisifoɔ ka ɔmo sɛ deɛ bɛn na ɔbaa pa esi ɔdwane afiri sɛ ɔbɛgyina adaka mu abusuafoɔ mo nso abusa mo ho sɛ ɛdeɛ bɛɛ pa na former president Mahama wosi awia wo na wosi wadi nkunim afei bɛwie court deɛ wosi dɛ obi ani nkunim yɛnsa nkɔtɔ aba no foforɔ abusuafoɔ yɛn nso yɛmusa former president Mahama sɛ wo a wode w'asɛm aba court wɔbɔ kɔ adu na wɔamfa nyinasoɔ bi ama no adɛn na wodeɛ wɔambɛtena box no amia ntoto ano abusua aha yɛde mmara ɛna yɛ adwuma ɛnwanwa wobɛka yɛ 2013 ɛno nso ɔmo de ka ho asɛm sɛ 2013 ɛyɛ Dr. Farijan ɛtena adaka mu nokorɛ Dr. Farijan tena adaka mu san sɛ ɛnyinasoɔ a yɛde baeɛ no na ɛmu pi yɛba ansa koraa ne yɛba ne yɛde 6,000 pink sheet na aba yɛdi asɛm ne kɔ so no ne yɛsa de another 12,000 ɛpem sia ɛne ɛpem edu mmienu kɔ n'akyi mu enti abusuafoɔ yɛn yɛde nyinasoɔ de ba enti na ɛho bɛhia sɛ Dr. Farijan ɔbɛtena adaka mu na yɛdoso no ɛnɛ yi mumbusa mo ho sɛ a judges from mpanimfoɔ ekura busa NDC foɔ sɛ na mo nyinasoɔ wɔ here my lord I have not brought that figure to court mamfa saa nkuntabuo na ama court ɛman dodoɔ sɛn na mo candidate ni nyaa I have not brought that figure to court yɛmfa saa ama no ama court dem ha sei na ɛkame akɔyɛ sɛ nyinasoɔ bi ani nsɛm mo ɛka nim enti wei ene baby a ene ye bedru ye na nyame ya adom a ochina court ebesai atena se na ensem a ye ka no ebiem yenso eye opani akotampaw wadi kan da na di se enya ade a ono nso no in witness ko obefre no sanse eye omo de asem beto court no omo nhye damfa asem kese bia no emba mbeto dwa enti mesrem ebiem omo kra de omo sa de hye omo kra tem kra se omo befra dansifo enum ebe wi ache no ene omo close omo case tese omo asem ankasa omo de bae omo kwadu omo de bae no omo nsem nya no omo tomanum to awie omo wie omo wie adansifo miensa pe no omo frɛ mo obi ahye omo keten se omo kofrɛ tu na aka no mramienu na aka ache no omo kofa mra na dabi obi anhye omo enti ade ne de untimi nhye obi se wa o case nya no osikinkyira wo pese obi nso ede na asem obegina adaka mu na odoso no enti abusuafo saa na ne yekowie na mesremo se na de bia mo me ho adagye na mo me hu behia ye mpanifo mo ha sei no
free eti nana bi na ebobo mpanifo a omo koja wonom ewo ye court ho no ti yesi ano no na ye betra sa na ye chesa ya babeta na menye aduane di babeta na aduane ye de pa ende se person busan say chicken no ne de na free hin esoso na de nso I was starting with the Chiana.
Says chicken. To me, go to
you are not heavy pa.
Better catch
no money you're saying
020 910 4748 020 910